In a prior video, I talked about the quickest way to go ahead and lose credibility and to minimize the value of your injuries in a medical malpractice or accident case. In today's video, I want to share with you what happens in that scenario where you are asked questions at a deposition and now are being asked about your problems and about your damages. What happens if you give an answer that is not entirely accurate? Will it destroy your credibility? Will it destroy the value of your injuries? Would you like to know the answers to those questions? Come join me for a walk through the neighborhood as I share with you the answers to those questions. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The answer is, if you have given answers that were unintentionally wrong, in all likelihood, it should not make a difference. Now, what do I mean? All right, during the course of a lawsuit, there will be an opportunity for the other side, for the defense attorney, to ask you hundreds and hundreds, if not thousands of questions in a one-day process called a deposition. Lawyers also call it an examination before trial. The answers that you give to those questions represent your sworn testimony and carries the same exact weight as if you are testifying in front of a judge and in front of a jury. The difference is that in these depositions, either they're being done in your attorney's conference room or, more likely, on a Zoom video call. Now, when you are asked questions about the extent of your injuries, and they will always, in every one of these accident cases, in every one of these medical malpractice cases, at some point they will start to ask you questions about your damages. They will ask you questions about your injuries. What are those things that you can no longer do on a day-to-day basis? How have your daily activities been affected as a result of these injuries? What things are you not able to do today? What things are you able to do with difficulty? What things do you do with pain? What things can you no longer do because of this disability that you have? Many people have the perception that it is important to go ahead not just to tell them the truth about the extent of their injuries, but they think that it will maximize the value of their case if they were to go ahead and overstate the damages that they experience, to go ahead and exaggerate the extent of their injuries. Well, actually, it's just the opposite. And the reason is that when you go to your treating doctor, you are going there with the purpose, and the sole reason of going is to hopefully have the doctor recognize what problems you have and to treat those problems you have with the intention of you getting better. You are not going there with the intention of deceiving the doctor or trying to get the doctor to over-treat you for injuries that you don't have. We all work off this baseline assumption that if you have been injured and you are going to a doctor for treatment, the goal is to try and have the doctor get you better, to try and improve your symptoms, to try and treat you to the point where you no longer are disabled. That's the ultimate goal. I don't think anybody, and in my career, I have not seen anyone go to a doctor solely for the purposes of boosting or enlarging the value of their injuries just so they could get the doctor to treat them if they didn't have certain problems or disabilities. I have never seen that. It may be true for some people, but I have never seen that in more than 36 plus years of handling these types of cases. So when an injured patient goes to a doctor, the expectation is now they are telling the doctor the truth about what complaints they have, what problems they have, what limitations and disabilities they have, with the goal that they want their doctor to go ahead and to address their problems, to treat them, to make recommendations, to perform surgery, something to take them out of their misery, something to get them better to functional levels so that they can go back to their lives, they can go back to working, go back to their family. That's what most injured patients want. They want to go back to the way it was before they suffered these terrible injuries, assuming it's possible. So now, during this pretrial deposition, the defense attorney will ask you many, many questions about your injuries and about what you can and cannot do. And they will compare and contrast what you are telling them in response to their questions to what you have told your treating doctors. They will already have all of your treatment records. They will have gone through and scoured and examined all of your treatment records. They will know specifically what complaints you made to each of these doctors on each of these visits. Now, here's the question. If you inadvertently say something that is inaccurate in response to an attorney's question, will it destroy your credibility? The answer is, in almost all cases where it is unintentional, the answer is no. If, however, you intentionally lie, You intentionally tried to deceive the opposing side. Now that's a bit different. And you might be saying, wait a second, how is the defense attorney going to know that I'm intentionally trying to deceive him, or that I'm simply mistaken and I don't have a good memory of what happened 3 years ago on January 7th at 3 o'clock in the afternoon? Well, let me share with you a couple of insights that I have over the course of my career. It is virtually impossible for you as an injured patient, as an injured victim, to remember all the details of everything that occurred. So when you are asked a question during your deposition, hey, Mr. Jones, can you tell me what complaints you had when you went to Dr. Gold's office on January 7th at 3 p.m.? What did you tell him you had a problem with? And you don't exactly remember. And is that going to harm you if you don't exactly remember? The answer is no, it's not. But if you were to go ahead and recite word for word, verbatim, every single thing you told him, now the defense attorney is going to be kind of confused about how you're able to remember every single one of those complaints. And now he'll take you through every single one of those visits. And if you were to remember every single detail about every single one of those events, that would be highly suspect. It would seem as if not only you had studied and memorized every single event in those records, it would be very, very odd and unusual for that to happen. And if you went ahead and said something that you believed was absolutely true, and now it differs from what you had said to your doctor during your treatment on a particular day, now the defense can go ahead and use that to contradict and to show that your testimony is wrong, your testimony, or at least your memory, is incorrect as it relates to a particular visit and complaints that you made. If you said, yes, I told the doctor 12 different things about problems I had, it was shortly after my injury, and now I told the doctor I want him to do everything possible. But yet in your chart, the doctor writes, patient has no complaints whatsoever, he refuses any treatment. And now when you are confronted with that information at your deposition, assuming the attorney actually confronts you with it then and doesn't save it for your trial, now if you go ahead and try and brush that off saying, oh, the doctor must not have written those things down, and blame the doctor or his office staff for not recording that information, now what do you think that does for your credibility? You're trying to throw the blame on him for not doing what he does on an everyday basis. That is not a great way to go ahead and establish that you suffered these significant injuries that are disabling. You want to go ahead and, to the best of your memory, tell the attorney what you recall happening. This is not a test. You are not there to memorize the record. You don't gain bonus points for reviewing the record and memorizing every single word. And if you don't remember something, it's perfectly okay. And it likely will not harm you and will not affect you because no one expects you to remember all those details. So why do I share this quick information with you? I share it with you just to open your eyes and help you with the perception that some people have, thinking that they have to know the answers to every single question, especially when it comes to talking about their injuries and the treatment that they were receiving and the complaints that they were making to their treating doctors. You know, I realize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.